Welcome to our course on patents and intellectual property. Intellectual property is big news and big business today. So this course is very important in providing you with the skills you need to operate in many different positions in the high-tech sector, medical sectors, the automotive sectors. All types of businesses are reliant on patents and IP today. This course starts out with an introduction to intellectual property, where we explain the difference between patents, trademarks, copyrights, trade secrets, and the various forms of intellectual property. We then move on to look at trademarks, explain what a trademark is, how you secure trademark rights, what makes a good trademark, the process of registering a trademark with the US Patent and Trademark Office. We then move on to copyrights, looking at what a copyright is, what they do, what is and is not copyrightable material, and then who owns the copyright and the fair use exception, because you can actually use copyrighted materials if you work within the fair use exception. So it's important to know how that works and what the boundaries are. Then we move on to patents. Now, patents, we dig into some detail here. The first section we have on patents is understanding patents. And there are some misunderstandings out there about patents. A patent is an exclusive right. It's a right to exclude infringers from practicing your patented invention, and to win possibly an injunction stopping the marketing and sale of infringing products, and or a reasonable royalty for the license to use your invention. We look at utility patents, design patents, plant patents. So this is an important section. Some people don't really understand that the patent is only a right to exclude. They sometimes believe the patent gives them a license to build a product, which is not exactly the case. Anyway, certain types of subject matter, are patentable and some are not. So we have a section on what is patentable subject matter. We look at novelty and obviousness and the key elements, the key features of the invention that you are going to have to prove if you are going to be able to be awarded a patent. Patent claims are very important components of the patent. They actually define the boundaries of the patent and define what you can assert against an infringer. So we explain patent claims, and we explain how they are used in infringement cases. Then we move on to patent prosecution. Now, the patent prosecution process is the process of negotiating your patent rights with the patent examiners in the Patent and Trademark Office. So the patent prosecution process is it's changing, it's an evolving process. We explain here what it takes to prosecute a patent. We explain the changes in the America Invents Act, the fast-track accelerated patent prosecution process that's recently been put in place, timelines and typical costs you can expect. So basically the whole process of what's involved in prosecuting a patent. Then we look at challenges to validity. If you have a patent and you assert the patent against the accused infringer, then the infringer can challenge the validity of the patent. And so we'll look at all the defenses that you can use to challenge if the patent is actually valid or not. Because having a granted patent is only a prima facie indication that the patent is valid. The many granted patents are later proved to be invalid in court. Then the pre-litigation process. The only thing you can do with a patent essentially is litigate it. So you can assert it against infringers. That's really the only legal right you have, except the right to file child patent applications from that original patent. If you're going to litigate it, one of the first steps in the process is the Markman process, where the judge that's been assigned the case actually interprets the language of the claims and decides how the language will be interpreted. So that's a very important stage, but it's pre-trial. Then at the litigation stage, we look at the different stages of the litigation. We look at the declaratory judgments, the defenses that are presented in litigation cases. We look at the remedies, injunctive relief, and damages. Now, we do have another course on remedies that covers injunctions and damages in much more detail, especially, and explains how they relate to patent cases as well. So once you finish this course, you might want to look at that course on remedies. The role of the jury. We go inside the Apple-Samsung case and investigate the role of the jury there and how they determined and made their decisions in that particular case. So this course covers, you'll see it covers a lot of ground, especially in the world of patents and patent litigation. We do have another course on patents called Patent Strategies. This one deals much more with business and monetization issues. So Patent Strategies covers patent licensing, monetization via patent sale. Of course, we talk about valuation. Again, we do have another course on valuation, but in that particular course, Patent Strategies, we talk about specifically valuation of patents. And we also talk about the different players in the patent landscape. So you get to understand what an NPE is, a non-practicing entity, commonly known as a patent troll, and what do they do, and why, what's their role in the ecosystem. We look at the different players. There are defensive patent aggregators, different players in the industry, so you get a good understanding of how the whole patent industry works from a business perspective. That's all in the Patent Strategies course. This is the Introduction to Patents and IP course, and so I hope you find this course useful, and I hope you enjoy the course.